Thank you very much. Thank you for the warm introduction and for the invitation. So I will present a working paper titled LLMs and the Collapse of Legal Indeterminacy, still very much kind of beginning stages of this project, so feedback is especially welcome. Okay, so we'll start with a little bit of a law intro. So in law, indeterminacy is known to be kind of an inherent feature of language more generally, but legal language more specifically. So this is a classic hypothetical that captures this idea, the no vehicles in the park hypothetical. So this seems like a very straightforward rule, right? No vehicles allowed in the park. But once you start to unpack it, you realize it's a little bit more complicated than it seems, right? This definitely covers things like bikes, cars, but what about like a drone or a skateboard or a toy car? So the language does not necessarily dictate one meaning, and some form of interpretation is required. So indeterminacy is both an inevitable consequence of linguistic structure, right? Law speaks in natural language, and language underdetermines meaning. But it's also a deliberate design feature that the law kind of uses intentionally and has very specific particular functions. So ambiguity, vagueness, open texture, they provide flexibility so the law can apply to unforeseen circumstances and allow for kind of contextual case-by-case determinations. It helps uphold endurance, so laws can stretch across time and shift with social change, right? Our Constitution is drafted with this very kind of high abstract language so it can absorb new meanings over time. Ambiguity elicits value judgment. It keeps law interpretive and not mechanical, and it helps uphold some form of institutional balance, right? This distributes judgment across legislators, agencies, and courts. Now, computable law, which I use to address kind of a very specific subset of technologies where legal norms are expressed directly in computer codes, making law itself executable by machine. So think of things like smart contracts or legal expert systems, automated welfare allocation decisions. They all stand in tension with legal indeterminacy, right? Code by its nature cannot really tolerate ambiguity, and every ambiguities must be resolved ex ante at the design stage. So if I have a term that has two meanings, I have to select one meaning. If I have a fuzzy boundary, a very specific threshold has to be set. And some of the lessons from past efforts to automate law, I think some of what we have learned is that law's open textured character has historically challenged mechanization efforts, and these same efforts systematically suppress ambiguity's productive functions. There's scholars that have gone so much to kind of argue that, the indeterminacy of the language should guide us towards areas of the law that are more amenable or not amenable to computation. So the more kind of determinate the language is, that more it's amenable to computation, and the more indeterminate the language is, the less amenable it is to computation. The question that I'm interested in for this project is whether or not LLMs, as opposed to computable law, preserve indeterminacy's productive functions and interpretive tasks. So I think intuitively there are reasons to believe why LLMs might appear promising, but a little bit of a spoiler alert, I'm going to try to argue that in practice, LLMs sometimes clash with legal indeterminacy in subtler or more insidious ways than rule-based models. Okay, so kind of taking a couple steps back, what do LLMs have to do with legal interpretation? So I think a fairly modest claim is that LLMs are increasingly operating as infrastructures of interpretation in everyday life. So I'll run through kind of a bunch of examples that I'll also weave in later in the talk. So this is one example. This is from a couple years ago. In Iowa, there's a law that bans schools from having books in their school libraries that contain sexual depictions. Now, one school, in order to comply with the law, uploaded its entire school book catalog to ChatGPT and asked it, which books have sexual depictions. The model outputted a specific list, and the school did, as a result, ban those books. So sex acts is ambiguous. There are different legitimate interpretations, and when the model, provides an answer, it necessarily adopts a particular interpretation of that term. Okay, this is from a recent paper, I think from the past few months, and it's also an interesting use case. It's taking LLMs and having them read over narratives of police officers that engaged in stop and frisks. Now, stop and frisks, police can only do if they have reasonable suspicion, so those LLMs are being used in order to audit whether or not these police stock narratives did in fact have a reasonable suspicion. Again, reasonable suspicion, this kind of, notoriously ambiguous term in law, and the model has to interpret it in some way. This is OpenAI, but I believe other frontier labs have a similar service where you can upload your content policy documents to ChatGPT or a different model, and it will interpret the rules and nuances of these documents and then make content policy determinations. So think of things like hate speech, incitement, these kind of ambiguous broad terms. And finally, the epitome of interpretation, legal interpretation. This is a case where a judge, Kevin Newsom, in a legal case kind of says, I wonder what the word landscaping means. I thought about it for hours and hours, and then he decided to ask ChatGPT and to kind of record his interaction with it and make the determination based off of what ChatGPT had said. He says, what is the ordinary meaning of landscaping? And he provides the responses from the actual legal decision. Okay, so what do we see here? Automated interpretation has expanded far beyond, the kind of thin computational law context. And across these domains, LLMs are becoming arbiters of meaning, grappling with the same kinds of ambiguous open texture terms that characterize law. So again, going back to my question, can LLMs preserve indeterminacy's productive functions in interpretive tasks? I think in theory, there are compelling reasons to believe the answer is yes, right? Maybe they might avoid the rigidity that made computable law so inhospitable to indeterminacy in the first place, right? And this can be by function of how these models work and operate. So rule-based models, they're deterministic. The same input is supposed to lead to the same output, and LLMs are probabilistic. So they sample an output from a distribution. For rule-based models, meaning is fixed ex ante at the design stage, whereas for LLMs, they fix meaning at inference time, which allows for kind of a case-by-case determination. Rule-based models map specific rules to an input, whereas for LLMs, they compute meaning from surrounding context. And finally, rule-based models output typically binary decisions, or maybe confidence intervals, whereas LLMs express result in language, which potentially allows for much more kind of nuance. They can maybe communicate uncertainty, conditions, or competing readings. So maybe a different way to kind of ask this or look at this is through this naive kind of 2x2 matrix, right? So if we saw that, there was a good symbiotic relationship between deterministic language, legal language, and deterministic rule-based model, but that all broke down when legal language was not deterministic. We saw that clash. What happens in this bottom row of the matrix? How does legal language fare against probabilistic technology as opposed to deterministic technology? And maybe in kind of the best case scenario, is there maybe a mirror image at that bottom right corner? Some again kind of mirror image between non-deterministic legal language and probabilistic LLMs. So the main focus of the paper is I try to answer this question and to kind of undermine this symmetry story. And I do so by offering 4 types of mismatches between non-deterministic legal language and probabilistic legal technology at the output level, the process level, deployment level, and evaluation level. So I'll spend the rest of my talk kind of going one by one with these mismatches. Okay, so we start with output level. So one thing to notice about that bottom right cell in the matrix, and I'll pull it over if you forgot, is that it rarely presents as the bottom right part of the matrix. What I mean by that, so when an LLM is operating in a domain where the governing language legitimately supports more than one reasonable resolution, it often returns a single confident answer. So we're in the bottom right side of the matrix, but it almost feels like we're in the top left side of the matrix. So what do I mean? So let's imagine we're in rule-based world and we have that same no vehicles in the park hypothetical. So here I would have had to kind of hard code what I mean by no vehicles in the park. I had to classify which vehicles are allowed in the park and which vehicles are not allowed in the park. Let's say ambulance is allowed and a bicycle is not allowed. For an LLM, I might ask, is an ambulance a vehicle under no vehicles in the park ordinance? And imagine that the model answers something that's the following. Yes, an ambulance falls within the ordinary meaning of vehicle because it's a wheeled motorized conveyance meant to transport people and equipment. So, this seems very close to what we're seeing with rule-based model. Almost seems like we're in the same world, right? This reads as if there is a factual right choice, as though there are ground truth about whether the ordinance covers ambulances. The answer almost sounds inevitable, as if no interpretive decision was ever made or required. And this is problematic because it both reinforces the authority reinforces the authority of the choice and shields value judgment from scrutiny. Now, this is an engineered example, but I'll show that it gets pretty close to what we're seeing at that legal case that I mentioned earlier. So the legal case that I mentioned, it was Snell versus United Specialty Insurance, and the question was a fairly kind of routine legal question that comes up. This was an insurance policy that covered accidents that happened in the course of landscaping, and the plaintiff had gotten injured when he was installing a trampoline. So the question was whether or not installing a trampoline is covered by landscaping. Again, kind of a classic legal question where language underdetermines meaning. So when Judge Newsom poses the question to the model responds as follows. Yes, installing an in-ground trampoline can be considered a part of landscaping. Landscaping involves altering blah, 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 you get the point. So here too, there are different possible legitimate interpretations of the word landscaping. Maybe it's maintenance work, maybe it's aesthetic design or environmental modification. But when the model returns an answer, it masks that interpretive choice and presents the result as if it followed from a rule. Again, kind of very similar to that rule-based world. The upshot is that models that are built to yes capture and represent richness and nuance of language ends up tending to mimic the deterministic certainty of rule-based models. Now, why is this happening? I think part of it is an interface problem, right? The kind of question answering affords closure, confident, objective answers. Part of it is the training pipelines that reward confidence and penalize uncertainty, but it's also on us, the kind of the deployment mechanisms, the way that we kind of force them to give us a binary answer because we don't feel like interacting or kind of reading something long, but also what we have come to expect from these systems, right? I might ask ChatGPT if I don't feel like going over and kind of doing my own research. I just kind of want a very self-contained answer. Okay, so that was the output level. Now we move on to process. Okay, so I'm going back again to a different example that I gave in the beginning. Iowa, again, there's a law that prevents schools from having books in their school libraries that contain sexual depictions. Let's say I ask ChatGPT about a particularly hard case, maybe something like the Bible, for example, right? The Bible definitely gestures at things that might be understood as sexual depictions, but there are also, probably pretty good reasons not to prevent it from being in a school library. So let's say I pose a question to the model, is the school and I are required to remove the Bible from the library on the ground that it contains passages describing sexual conduct? And let's say the model says something like this: no, although the Bible contains some passages that describe sexual conduct, it cannot be fairly treated in its overall character as a book. Okay, blah, blah. Is this plausible? Is this justified? Maybe. Yeah, sounds like a pretty standard answer to me. But if the model said yes and gave a justification for that, sounds also pretty reasonable and pretty justified, right? So what am I getting at? This is a genuinely hard case. And if this question were to be posed to a human, different human judges might have reached different plausible outcomes. And judges do choose among multiple legitimate interpretations in some contexts. So for when it's human judges, what makes us accept this choice as legitimate when another was equally defensible? Or maybe a different way to kind of ask this is, what separates, judicial discretion from mere preference? How do I know that a judge, didn't just kind of choose one option on a whim, but this is something that represents a deeper form of discretion? Hear the cynicism. So at least part of the time, legitimacy depends on institutional features that discipline the process by which the resolution is reached. Again, specifically when there are different multiple legitimate outcomes. So in the paper, I try to kind of isolate different features, and I'll give two examples here. I'll talk about reasons and I'll talk about authority. So, I'm sure you know this, but in judicial context, in some contexts, there's a reasoning requirement in some, shape or form. Now, giving reasons has different kinds of functions, and here I want to focus on a specific kind of function that reasons has, which is its inwards and disciplining role. So Frederick Schauer, who's a legal philosopher, makes this point that a reason is always more general than the result it supports. And because of that, reason giving kind of has this, it binds future commitments. It has this kind of disciplining force. What do I mean? So if I say, for example, I like lobster because lobsters are red and they have claws, the explanation is broader than the thing itself. And then if somebody gives me a crab and I say that I don't want to eat it, might be justified if they will be a little bit weirded out by that. Or if I say, I'm sick, or I can't come hang out with you tomorrow because I'm sick, and then the person sees me out and about, they might have reason to be kind of disappointed in me, right? So when I give a reason, I'm binding myself towards kind of future commitments. And at the same time, reason giving doesn't only bind future commitments, but it also binds the current result. Why? Again, some legal scholars talk about this phenomenon, it won't write, right? Sometimes if I, arrive, I have like a quick intuition about an outcome, a traditional outcome, and I try to write it down, and I see that I can't justify it, that might, shape the response. The fact that it's difficult to justify an outcome might discipline the outcome that I might arrive at, essentially. LLMs, of course, operate outside of this architecture of constraint. They're not bound by that. A different example, again, of this process disciplining forces is authority. So legitimacy sometimes depends on the fact that there was an actor that was authorized to decide. And this is easiest to see where authority is what does the entirety of the legitimizing work. And I think particularly interesting examples is where we see an inverse relationship between reason giving and authority. So for example, take voting, right? For voting, you don't have to justify my vote, obviously, because of the weight of the fundamental right that I have to vote. Or juries don't have to explain their verdicts because of kind of the democratic pedigree of the process by which we choose juries and what they represent. Here too, LLMs were not entrusted with authority, at least for now, to settle indeterminate legal questions. Okay, so this is process, and I guess the point, again, is that the LLMs are not kind of disciplined by those same institutional legitimizing rules that kind of make us accept one outcome when there's a different, equally reasonable output. Okay, now we move on to deployment. Deployment, I want to talk about a particular kind of dynamic that I argue that we're maybe likely to see in deployment mechanism or deployment contexts. So deployers who use LLMs to apply indeterminate standards, I think will face this form of specification pressure. So again, taking one of the examples that I mentioned earlier, content moderation. So content moderation, again, we have platforms that might upload content policy documents and have an LLM make these content policy determinations. Now, one thing that I think we have seen pretty consistently with content policy is that people are finding inconsistencies. So when they're letting these models execute their content policy documents, the models, sometimes say yes and sometimes say no for kind of very similar content. And we see kind of a bunch of studies that are pointing at the same direction. So again, if I let an LLM kind of execute content moderation policy that is supposed to flag hate speech, we're seeing inconsistencies. I think in practice, what this means is that deployers are going to experience the bottom right of the matrix, so again, in non-deterministic legal language with probabilistic technology, as unstable, right? Outputs shift across models, interactions, and minor prompt variations. And this we see not only in content moderation, but in every kind of open legal interpretive context. As a result, I argue they may be pushed to convert open textured standard into a more determinate rule-like representation so that the system behaves more predictably and can be audited against stable criteria, right? So I give an example of this. This is kind of a guidance that's offered to people that are using LLMs for content classification. And basically, this guide advises deployers to order policy categories as sequential sieves and make them strictly mutually exclusive and define the inner and outer contours of every context with rigid examples and counterexamples, and policies that fail to concretely define the terms that they use, they warn, will often result in misinterpretation by LLMs. So they give an example of something like this. I am aware that you can't really see it, but it's like kind of taking a very, very broad context concept and breaking it down to very, very, very specific instructions. Now, this of course has advantages, right? Maybe to some of us, this doesn't, jump out in the beginning as something necessarily negative, right? The decision maker, not the model, is in control of making the interpretive decisions. This constrains the discretion of large language models and pushes the model to act more consistently by eliminating indeterminacy. But I think the downside of this, we're converting a broad indeterminate standard into a more rule-like framework. And this sacrifices the benefits of indeterminacy that I talked about at the beginning of the talk, especially flexibility and context sensitivity. Right, so and I think something interesting to note is that the pressure to specify is probably greatest where the standard's openness matters most. So the harder the question is, the more we're likely to see kind of erratic behavior, which is going to be kind of the biggest, stronger to push it down and to kind of over-specifying. Now, again, why is this problematic? Because this kind of recreates that same dynamics that LLMs were supposed to overcome, that indeterminacy is resolved upstream ex ante, just as it was with rule-based systems. So again, with rule-based systems, beginning of my talk, kind of explained this dynamic where we have to kind of rewrite the law in a very simplified, deterministic way, and that takes away the benefits of indeterminacy. And now we've kind of done this, kind of 360 and ended up at the same place. We're the ones that are writing law in a very, very specific way, and by that kind of undermining the benefits of indeterminacy. Okay, last mismatch in evaluation. So here, I'm sure you're aware, there's a growing body of scholarship that attempts to assess how large language models perform on interpretive legal tasks. So we've covered a lot of examples that are looking at how LLMs, actually do interpretive legal tasks. There's a scholarship that evaluates how those models do, right? So there are now, a few dozen papers that are doing similar things. What I argue here is that some of these studies do not take seriously enough the probabilistic nature of the technology, and other studies do not take seriously enough the indeterminacy of the legal material itself. So I will focus on that second part of the argument. So again, I'm going to take an example, the example that I mentioned earlier, about stop and frisks in the US. Just want to say I'm not calling out this paper specifically, it's an interesting use case. I actually think this paper has a pretty sophisticated methodology. The setup here, this is in the US, police stops are only legal if the officer had reasonable and articulable suspicion. And officers document the reasoning in written narratives after the fact, and LLMs are fine-tuned to read these narratives and classify the stop as legal or illegal. So this is, again, an interesting use case, a useful use case, right? Police officers, I think I remember the number, maybe 12 million stops a certain amount of time in the US, and they're not being audited, or if they are being audited, it's humans, and there's a limit to how many stops humans can audit, and now we're using LLMs that can go very easily over all of them and audit whether or not the officers actually had reasonable suspicion. Now, a natural question is, how do we measure accuracy, right? So this paper claims to have, it says with over 90% accuracy. What is accuracy here? So whether a stop is reasonable is an interpretive question with no clear ground truth. So option one is maybe we use police stops as ground truth. So LLMs, go over the narratives and it tests it and have to see whether or not, or have to kind of classify whether or not the police had a reasonable suspicion, and we try to match that with the actual stops. Now, of course, this is a very silly metric because police behavior is exactly what we're auditing, so using it as ground truth is circular. So that doesn't work. Okay, so maybe option two, maybe we compare it with human labels. So maybe, we start with crowdsourced layperson's labels. So we, have a bunch of law students look at the narratives and say, is this reasonable suspicion? Is this not reasonable suspicion? And then try to compare LLM classifications to that. But that's problematic because it might not track legal doctrine because these are not legal professionals. Okay, so maybe we try experts. But then which experts? Do we take police officers? Do we take lawyers? Do we take judges? And also, what if they disagree? Do we take kind of a majority vote, or do we treat inter-amputator disagreement as signal? And also, that's just the law side. What do we do about the technology side? LLMs output a distribution. Do we compare the distribution to the distribution of the people? I think that kind of there's an endless meta questions that kind of spin off this option. In option three, maybe we use LLM self-consistency as ground truth. So if the model gives the same answer across many runs, we treat instability as evidence that it's correct. But it's also pretty silly, right? Because consistency isn't necessarily correctness, especially when there are multiple legitimate outcomes. And forcing consensus may actually just entrench one's interpretation of an ambiguous standard. So all these options are options that are we actually see in the literature all these options, and there's kind of a mess in the literature. We're seeing a lot of heterogeneity in the types of outputs that people are adopting when they're using them for, again, legal evaluation. So again, the upshot here is that it seems like the notion of ground truth for interpretive questions with multiple legitimate interpretations is somewhat incoherent. The literature uses different metrics because the target itself is unsettled. And again, those three options are options that legal scholars did use. And it's interesting to note that the literature barely acknowledges this. So legal AI evaluation often smuggles in a theory of correctness that it does not necessarily defend. I don't try to propose a solution to this, and I'm just kind of pointing out, again, the incoherentness of the notion, but I do want to bring this quote, which I thought was pretty interesting. This is from a hermeneutics paper, a computational hermeneutics paper. And the claim that it's making is maybe we should start thinking about evaluation in the context of LLMs as something, as kind of take inspiration from hermeneutics. So they say, to categorize, and they're not talking about specifically legal context, but they say to categorize their outputs as binary right or wrong responses presents a similar profile of problems as asking whether Anna Karenina is a superior novel to Jane Eyre, blah, and whether Andy Warhol's Soup Can painting were a critique rather than a celebration of American consumerism. So again, they're interpretive open questions, and to force one response, again, kind of collapses this indeterminacy. So again, working papers, I don't really have solutions or big takeaways, but two that I wanted to mention before I finish is that it seems that LLMs are not really a solution to legal indeterminacy, right? I tried to trace in the paper kind of the arc from computational, kind of these rule-based models and how they clashed against indeterminacy. I think it seems like LLMs can handle them better, but discretion exists whether we like it or not. And I think the different mismatches kind of show different places where we're kind of pushing it to be resolved. So LLMs present maybe new ways of managing and obscuring it. And a different way to look at it is that generative AI in its own way is another reductionist approach to law that still leaves much of what the actual practice of law behind.